Why are some patent invalidation decisions overturned despite obvious lack of inventiveness? The principle of hearing might be the answer. Recently, the Intellectual Property Tribunal of the Supreme People's Court issued an important ruling summary clarifying the principle of hearing in patent invalidation reviews. To put it simply, this principle requires that before declaring a patent invalid, the collegial panel must inform the patentee of the specific reasons and evidence and provide them with an opportunity to present their arguments. This ruling stems from a specific case. The invalidation requester argued that a patent claims lacked novelty compared to evidence 2, and therefore also lacked inventiveness. However, after review, the collegial panel concluded that the claims did possess novelty, which meant the original invalidation ground, lack of inventiveness due to lack of novelty, no longer held. Nevertheless, the panel ultimately invalidated the patent, reasoning that the claims lacked inventiveness when combining evidence 2 with common general knowledge. Dissatisfied, the patentee filed a lawsuit to overturn the invalidation decision. After going through first and second instance trials, the Supreme Court's IP Tribunal ruled that during the review process, the China National Intellectual Property Administration had failed to give the patentee an opportunity to respond to the new reasoning, i.e., the combination of evidence 2 and common general knowledge, thereby violating the principle of hearing. As a result, the invalidation decision was revoked. Some might ask, since the invalidation requester had already submitted evidence 2, wasn't the panel's review an exercise of its ex officio authority? True, this aligns with the principle of ex officio review, but it doesn't mean the principle of hearing can be ignored. When the original reasoning, lack of inventiveness due to lack of novelty, no longer applies, if the panel identifies other grounds for lack of inventiveness, it must still inform the patentee and consider their arguments before making a decision. Thus, the principle of hearing in patent invalidation reviews is not about the substantive merits of the case, but about procedural fairness. Even if the invalidation decision's conclusion on inventiveness is correct, if the process violates legal procedures, the decision should still be revoked. This case serves as a reminder to invalidation requesters. When filing an invalidation request, it is crucial to comprehensively consider all possible grounds and evidence. Even if a claim lacks novelty, it is important to explicitly argue alternative grounds for lack of inventiveness based on the same prior art evidence. Otherwise, the evidence may go to waste,